who were being identified by the appeal system as bogus. And yet you might think, watching the news, that any Iraqi has some cause of concern on the return to Iraq. Moving back then to the text of Article 15 now, let's just try and, now we've looked at a bit more of the backdrop to the history of the Refugee Qualifications Directive, let's look back at the text and see if we can do it better than I did in my first stab at elucidating it. So, serious harm then, for these purposes, is serious individual threat to a civilian's life or person by reason of indiscriminate violence in situations of international and internal armed conflict. And one needs to read this as a whole. Yeah, it's not the most beautiful piece of drafting one's ever seen. But when one goes back a bit, to those of you who can read it, to Article 2E of the Qualifications Directive, it puts that whole provision in context and says a person eligible for subsidiary protection means someone who does not qualify as a refugee, but in respect of whom substantial grounds have been shown for believing that they would face a real risk of suffering serious harm. Yeah. So substantial grounds for believing they face a real risk of suffering serious harm. What serious harm? Serious and individual threat to a civilian's life or person. Read as a whole, it would seem that actually 15C is saying that a risk of a threat to a civilian's life or person brings this provision alive. And that, in international law terms, is a very radical proposition. It will suddenly put the European community quite at odds with anything that the European Court of Human Rights has ever said when evaluating protection claims, or anything that any Commonwealth court has ever said looking at refugee cases. For this reason, the standard of proof accepted in protection human rights cases has always been said to be people facing a real risk of torture or inhuman treatment. And in refugee cases, the people face a reasonable degree of likelihood of persecution. And when judges have sometimes given examples of what degree of risk that might indicate, they've sometimes talked about a 1 in 10 chance. Lord Justice Sedley in the TIAF spoke of the fact that if you had a 1 in 10 chance of a car breaking down, most people would accept that that was a real risk of the incident happening. And so someone who faced a 1 in 10 chance of persecution is a refugee. But how does that pan out in terms of the actual reality of armed conflict? I looked at a famous incident of armed conflict in terms of attacks of civilians to see whether or not that interpretation would assist. The bombing of Dresden is still spoken of, in lucid terms, as a historic incident of bad behaviour which had ill effects towards civilians. Now, Dresden, in 1939, had a population of 642,000, and by 1945, probably 842,000 because of refugees. And in the bombing, the death rate in the bombing, on the worst few evenings in 1945, is put by various figures at no more, I think, than 22,000. There are different statistics. I got all this on Wikipedia here. And so you come up with statistics here that would put it, this isn't perfect arithmetic here, but roughly speaking, that in the worst night, the very heat of the Dresden bombing, there were no more than 3% civilian casualties. And yet, compared with what the refugee law judges would say requires, what a well-founded fear of persecution is, you rather wonder what the Germans were complaining of. And so, now, looking back at that statistical analysis, and rereading Article 15 on the standard of proof, substantial grounds for thinking that there is a real risk of a serious and individual threat. You see, none of the other protection provisions outside armed conflict have that phrase, individual threat. It seems that 15C is trying to protect civilians from a risk of a threat of harm, not only a risk of harm. And that is something that could have enormous significance. You look at the statistics on Iraq here, the Lancet, writing in 2004, but the statistical analysis yet to be discredited, I think, by any serious source, said that 642,000 Iraqis had died in the first 2 or 3 years post the invasion. And mostly civilians, given in the sense that the Iraqi army didn't fight for very long, in a regular sense. So most of the civilian casualties, in fact, over the entire period, most of the casualties over the period would appear to be civilian casualties. And in fact, if you look at the continuing figures ever since then, things aren't improving. The Home Office line is that not that many people are currently being killed in Iraq. But their statistics are entirely based on figures from the multinational forces, who appear to only actually count attacks on themselves. And it's remarkable, that I doubt they poke their heads out of their tanks for very long, that they spot any civilian casualties at all. So the Lancet statistics would appear to be much more reliable as a percentage death rate. What else? I want to go through this quite quickly now, on using this provision. So it does seem, firstly, as I said, that the European draftsman of this had a broad-out protection in mind. Also, we can see that serious individual threat is much broader than traditional forms of refugee or human rights protection, arguably. Civilians life of a person. But what do they mean by that? Now, given that this protection provision kicks off in terms of armed conflict, in times of armed conflict, it might be thought that the incidence of armed conflict would be a very good place to look in terms of deciding what is a threat to the life of a person. The Home Office don't like that idea at all. The government lawyers say that life of a person means being killed, and that's an end to it. Or at least shot, or seriously injured. But is that right? The laws of war are very complicated animals, and I put in page 3 onwards just a few extracts of them. One source of inspiration as to what is relevant threats to life of a person is Common Article 3 of the Geneva Conventions. Geneva Conventions, done in Geneva back in 1949, were designed to avoid any repetition of the bad behaviour seen towards civilians in the course of the Second World War. Second World War, civilian casualties outnumbered military casualties by a very significant rate, whereas in all the previous wars, it was tended to be the armed forces that took the brunt of the casualties. So in 1949, Common Article 3 of the 4 Geneva Conventions on War sets out certain kinds of bad behaviour that should be prohibited for all time. Violence to life or person, in particular murder of all kinds, mutilation, cruelty and torture, taking hostages, outrages upon a person's dignity, extreme lack of fair trial, and the failure to collect and care for the wounded and sick. Now that last provision is an interesting one, yeah? If you look at Mogadishu in 2007, the International Committee for the Red Cross say that hospital capacity in Mogadishu has gone down by a factor of 3. That's to say only a third of the hospitals in 2007, January 2007, was still operating in December 2007. You might say that the laws of war suggest extreme threats to civilian life or person, given that evidence. That's Common Article 3. Another possible source of law as to what's life or person is Protocol 2, which you see in page 4 of my note. Protocol 2 of the Protocol Additional to the Geneva Convention from 1949. This was produced in 1977, a treaty that's heavily signed up to, in fact I would say almost universally signed up to now. I doubt you know who's signed up to it, but most people have signed up to it. And it extends the protective provisions of Common Article 3. So now, it prohibits civilians being exposed to collective punishment, hostage-taking, terrorism, slavery, pillage, threats to commit any of those acts. Another possible source of law as to what's life or person is Protocol 2, which you see in page 4 of my note. Protocol 2 of the Protocol Additional to the Geneva Convention from 1949. This was produced in 1977, a treaty that's heavily signed up to, in fact I would say almost universally signed up to now. I doubt you know who's signed up to it, but most people have signed up to it. And it extends the protective provisions of Common Article 3. So now it prohibits civilians being exposed to collective punishment, hostage-taking, terrorism, slavery, pillage, threats to commit any of those acts. Also it says that objects of worship and cultural objects have to be looked after, and it prohibits forced movement of civilians. Well, if you look at the ethnic cleansing that, for example, took place in Baghdad throughout 2006 and perhaps early 2007, on a Protocol 2 test of what is life of a person, very difficult to say that the life of the person is professional in that sense.